now move forward to the second case on our docket, Ruiz versus Tenet Hialeah Healthsystem, Inc.
Mr. Chief Justice, good morning, and may it please the court. Philip Parrish, and seated to my left, George Gutierrez on behalf of the petitioner, Rolando Ruiz. This is a very simple case, and the issue presented is whether an anesthesiologist who negligently clears his patient for surgery, for an elective surgery that should not have occurred because he missed a strikingly abnormal, not just an abnormal, but a strikingly abnormal lab result, is at least a proximate cause of his patient's death in that surgery. I submit that under this court's case law concerning both directed verdict and causation, that the answer to that question has to be yes, and that the Third District Court of Appeal expressly and directly conflicted with all of those decisions, notwithstanding the fact that it didn't cite any decisions from this court. It did present sufficient facts. We know from the facts that Dr. Lorenzo stated in an interrogatory that he did the pre-anesthesia clearance. We had expert testimony that the purpose of the pre-anesthesia clearance is not simply to clear a patient for the type of anesthesia that's going to be provided, but also to check all of the medical lab results and records to see that there are no medical contraindications. Now, in this case,
what was the cause of death?
The cause of death is exsanguination during the surgery. Now,
What did
yes.
did the surgeons performing the surgery did they not sign the death warrant? I'm sorry, the death warrant,
Right.
the death certificate. We do so many death warrants. Basically claiming that it was a heart attack.
They did. The coroner's report suggests that it was exsanguination. So there is some evidence there by virtue of what the surgeon said that it was heart-related. I think the record is fairly clear, and to be honest, is that the death was primarily through exsanguination.
Okay, exsanguination meaning bleeding to death. How did that happen?
First of all, these types of surgery they're bloody because it's a cranial surgery. And in fact, as Dr. Lorenzo noted, there was extra blood ordered for this surgery. So we know, so Dr. Lorenzo understands that it's a dangerous surgery, it's a cranial surgery. He concedes that if he had seen this abnormal report of protein in the urine.
The tumor was attached to the cranium, was that correct?
I'm sorry, Your Honor?
The tumor?
Yes.
Where was attached to?
It was sort of a lesion that was at on the occipital area of the scalp, and it was actually sort of bleeding through the scalp, but it had to be...
So to remove the tumor, incisions had to be made around it, am I correct? Is that where bleeding took place?
There was testimony that the bleeding occurred through the bones. There was... So I'm not as familiar with the exact process in which the bleeding occurred. It's more or less conceded for purposes of the appeal that she died during surgery. It's a bloody surgery to begin with, and that's why they ordered extra blood. And there were allegations against the surgeons who were found negligent for not stopping the surgery when there was a significant loss of blood. But for purposes of Dr. Lorenzo, he knows and he concedes that if he had bothered to turn the page, he looks at page 1661 of the supplemental record, which has the hematocrit on it when he's checking off the form. He also checks off that there's no renal problems. Well, he doesn't look on the next page, 1662 of the record, to see that the patient had 100 milligrams per deciliter of protein in her urine. And the way these...
Yes. Breach of duty really is not the issue. It's causation, correct?
Yes, that is what the third district ruled, and that's what the basis of the trial court granted the directed verdict. When she said, I'm going to assume that he did the entire pre-anesthesia clearance, what's the evidence of proximate cause? And Mr. Gutierrez said to her, well, that...
So under McCain, the causation that we're looking at is the legal cause or proximate cause of the specific injury that the plaintiff is seeking recovery for. Is that right?
Correct.
So, and just to maybe another analogy, if someone gives a car key to an underage person who doesn't have driving experience, they know the person doesn't have driving experience, doesn't have a driver's license, shouldn't be driving, and assume that we all would agree that would be negligent to send them to the store to get something for you in that car. On the way, the young person is driving the speed limit and is obeying all traffic rules and actually, surprisingly, maybe doing a good job. And then tragically, a drunk driver shoots through a red light and causes an accident that the young driver could not have avoided and causes injury, maybe even death, of that person. And so what would be the proximate cause, the legal cause of that injury that young person suffered?
Well, in that case, and again, that's a different case than what we have here,
Right.
but in that case, the proximate cause would be that you gave the car keys to somebody who was not qualified to
Wouldn't the
drive the car.
proximate cause be the negligence of the drunk driver?
No. Well, but again, so that gets to, I take it your question goes to issues of, and there are cases where a court has said something is too remote.
I mean, because
but this is not remote.
The direct and proximate cause of the injury, in that my example would be the direct driver. It would not be foreseeable that the person who gave the keys, although they were negligent, they wouldn't be the they wouldn't be the legal
But
cause
it's very
under
foreseeable,
Florida
Your
law.
Honor. I'm sorry, didn't mean to step over you. It's very
But
foreseeable.
just if you could answer my question, and my hypothetical, would the person who gave the keys negligently to the driver be legally responsible because they proximately caused the injury or death of that person?
Well, it could be, because it's not a
So
bizarre or
okay.
it's not necessarily a bizarre or unforeseen instance. But again, I think that is a different case, a much more difficult case.
Your argument here seems to be, I mean, I think you would concede that the people who are responsible for controlling the bleeding or getting extra blood are the ones that are responsible for the surgeons for this person bleeding out, right? I mean, they're the most direct cause. You would agree with that?
Sure, but we have concurring causation instructions, and we have a Fabry defenses for doctors who are not, or who are even further removed. In fact, we sued the internist in this case.
Okay, but just so that I understand the evidence, there was no suggestion in the evidence that the protein in the urine would have led to extra bleeding or would have any immediate or direct or indirect.
Well, it depends on how you define direct and indirect. Here,
Okay,
the
so
issue
I mean,
is
your argument is that if this doctor had notified the surgeons, as he should have done, there was evidence that says that, and I think he admitted it, that there was protein in the urine, then they should have stopped the surgery because they should have thought that something else was going on.
There's testimony in the record both that the anesthesiologist had the power to stop the surgery themselves. By the way, Dr. Yates testified he would have stopped the surgery to find out what the reason was for that. Dr. Moreau, who was the boss, essentially, of Dr. Lorenzo and Dr. Velasquez, he's the chief of anesthesiology and the chief medical officer at Hialeah Hospital, testified that you cannot permit a patient to go to surgery with these abnormal...
Isn't your argument that the injury, the bleeding out, the death would not have been caused because the surgery never would have happened?
Yes, and it was an elective surgery. Now, Dr. Mazzai, our expert, said if this had been an emergency surgery that you had to go to no matter what, then it doesn't get stopped for these bases. But when you have a situation with a patient who had not yet been fully diagnosed, one of the purposes of the surgery was to get a sample and send it to pathology. that doctor knows that the protein, if he looks at it, means that she's suffering from multiple myeloma, which is not treated surgically. So the doctor, if he had looked at this next page, which again, I was about to say earlier, that the abnormals are in the middle of the page. They jump off at you. All he had to do, he looked at the prior page. If he turns the page, and we know that he got that far because he checked off the renal box on the anesthesia form. He is sending somebody he makes a mistake, a strikingly abnormal result, which would have led him and the surgeon to cancel an elective surgery. It was an elective
I'd like
surgery.
to ask you a question about the jurisdiction here. I'm looking at the third district's opinion, and I see a statement there. It says, none of the expert witnesses, after the court has recounted the expert witnesses who testified, none of the expert witnesses testified that Dr. Lorenzo's evaluation of Espinosa fell below the standard of care, such that any breach more likely than not caused Espinosa's death. Okay, that's what they say in the opinion. How does that, I'm trying to figure out where the conflict is here, because that's what they say. I understand you don't agree with that.
But because that statement, first of all, if the statement had stopped with, none of the expert witnesses testified that Dr. Lorenzo's evaluation of Espinosa fell below the standard of care, period, that would be one thing. But it says such that any breach more likely than not caused Espinosa's death. Now, we take that has to be tied in to their penultimate paragraph of the opinion, where they say the record is devoid of competent substantial evidence upon which to conclude that the blurry EKG or the abnormal protein level results caused Espinosa's death. Why do they say that? They say because the record is abundantly clear that the primary cause of Espinosa's death was exsanguination. So they're not saying that there was they can't say there was no expert testimony that there was a breach of the standard of care. That would be either a misinterpretation or a misrepresentation of a record.
They
But
said it. You're saying
such
they
that.
couldn't say it, but they did say it. And so, that's what confuses me, because we have to go on what they say, in determining whether we have jurisdiction, we have to go on what they say in the opinion.
Right.
We can't go on your reinterpretation of what is said in the opinion. And I'm just struggling to understand how, they say there's no expert testimony, and that's there.
And then they explain why they're saying that. They're saying that for the
That seems
reasons
like
I
a
think that
pretty creative
Justice
reading
Lawson
of
was getting
the
at, which
opinion.
is that because the missed protein in the urine is not the medical cause of the exsanguination, that there cannot be proximate cause here, when
But
in
from
fact,
all I would know from looking at the opinion, they're simply repeating what the expert said.
but we know that that's not the case.
Well, but we don't know that from looking at the face of the opinion, do we?
Well, we know that they put in the word. They didn't stop with no expert testified that there was a breach of the standard of care. They go on and say they tie it to proximate causation. They then say why it is that they don't believe there's proximate causation here, and that explanation of proximate causation under the facts of this case, which are set forth fully enough in the opinion to know that what they're saying is what I've just said, that they're saying that missing protein had to be the medical cause of the death, rather than the missing protein is you're negligent. You look at the Dr. Lorenzo independently. Did you do what you were supposed to do? Did you act as a reasonably prudent physician, as this court said you must look to for each and every physician in a medical malpractice case?
You're making arguments as to the merits, but you're still not touching on the question on jurisdiction.
Well, Your Honor, I'm sorry. I've answered the question that
You've preliminarily won on jurisdiction, and you may ultimately win on jurisdiction.
Correct.
But I'm mystified by how there can be this conflict when I look at what actually the opinion says.
the only way that I can interpret this opinion, knowing what Judges Fernandez and Suarez knew, which is that there was expert testimony that did all of that testified about a breach of the standard of care, is to look at what they think is proximate cause, which is what conflicts with all of this court's opinions, McCain, Hellman, that this is not a scenario where you have a freakish and improbable chain of events. We have a very direct chain of events.
If I understand what you're saying,
there,
to do that, you've got to look beyond what is actually in the text of the majority opinion.
no, you just have to read you have to read the text, the opinion, I think, by looking at the entire sentence there, not just stopping it with no expert testified in the state of care. We all know if no expert testified in the state of care, directed verdict absolutely is going to be entered. But they say which then caused, and then they explain it later in the opinion that in their opinion it didn't cause it because she died from exsanguination and the protein, the strikingly abnormal protein lab result, that protein didn't cause the, medically, it caused it because it should have alerted the physicians not to send her into this elective surgery. And that's a straight but-for tort, proximate causation
Maybe I could try
analysis.
this a different way. I mean, you agree that the Constitution limits our ability to hear cases. We can't act outside our authority, right? And in this case, you've alleged express and direct conflict, and you would agree that it has to be on the face of the opinion. You have to be able to look at the opinion and see the conflict.
Correct, that the law was misapplied.
Okay. From the face of the opinion.
Right.
And back to Justice Kennedy's question, can you point to me on the face of the opinion the legal misapplication that you can see in the majority opinion?
It's the penultimate paragraph. It's saying
What-
that this can't be a proximate cause because the strikingly abnormal lab result or the blurry EKG did not directly cause the death when...
And from the opinion, since all the opinion does is say what the expert said, then how can you tell that that's wrong, I guess, is how can you tell that it's a misapplication of prior precedent from that paragraph? That's what I think
Well,
we're struggling
I think
with.
I'm saying you have to tie that full sentence from the beginning of the opinion, where it doesn't simply say nobody testified to a breach of the standard of care. It says such that it caused, and then when they get to the point and when they're describing such that it caused, they describe facts which, under this court's authority, would require them to reverse, not to affirm.
Mr. Parrish, let me ask you this question.
Yes.
If we assume we have jurisdiction under the theory that the third district didn't properly explain primary cause, proximate cause,
Right.
they just say, I mean, the conclusion is that, if I'll quote from it, the record is abundantly clear that the primary cause of Espinosa's death was such and such. Well, we know that under Florida law, you can have responsibility, liability, if there is less than primary cause. You can have multiple causes, so, but let's get that behind us.
Right.
I want to be sure I understand your argument, and that is that because there was some laboratory finding that has nothing to do with what happened to this patient, but it was such that they would have not proceeded with surgery just to find out about that condition. Is that what your argument is, and that's enough?
Except that I have to disagree with you that it has nothing to do with. It may not be the medical cause, but it has everything to do with the fact that she was sent into surgery. And it is never,
that's my point.
a...
Okay, all right, excuse my language. I misused the language. I'm trying to get to the very practical question and the very direct question, and that is that the laboratory result would have just stopped or postponed the surgery.
Right, and
That's it, nothing more.
That is
There's
essentially...
no
Your Honor.
testimony that that laboratory finding contributed in any way to the actual outcome, the bleed out or whatever actually happened.
That is correct.
Okay, so that's really the issue we got to talk about and find out. I mean, it's that, because I respectfully, and I respect your arguments, you're a talented lawyer, but there's so many cases all across the state of Florida that say, for example, that not having a license or going too fast is not a contributing cause to an accident when somebody, a DUI, runs you in the rear. So I'm sorry you haven't convinced me that that's the law of Florida, respectfully. But I'm trying to get past the superficial stuff and see if we really do have something that's dangerous to the consistency of Florida law. So that's, and I'm having a problem, respectfully, with how you get to causation of any kind in this case?
Because if you send someone to surgery when you shouldn't have sent someone to
Okay,
surgery,
I understand your argument.
then you
Okay.
have, then that, how is that not the proximate cause? It's not a bizarre, it's not a freakish and improbable occurrence that something can go wrong.
Okay.
In fact, Your Honor, let's assume that she survives this surgery. She could have sued for having to go through the surgery when it was unnecessary, when it was an elective surgery, and had this been caught, the correct diagnosis, that's the,
Under
would have been multiple
your
myeloma.
argument, assume for a second that I have some kind of ailment that's going to require the amputation of my right leg. And I'm wheeled into surgery that morning, and I go to the preliminary test like your client did here. And a lab report is not read that would have impeded the doctors from conducting surgery. So during surgery, they amputate the wrong leg. You know what I'm saying? So what you're saying basically is, had they read the lab report, they would not have conducted the surgery, and they would not have cut off my wrong leg.
Well,
I mean, I guess what I'm
okay,
looking
so
for is
that's
the connect the
freakish and
causation.
improbable. Cutting off the wrong leg, I would suggest, is freakish and improbable. Having someone die in a surgery that's known to be bloody, where they had to order excess blood, and a completely unnecessary elective surgery, where everybody here, the surgeons testified, if I'd known about if I'd been alerted to this, I wouldn't have had the surgery. You treat
Mr.
this
Parrish,
with-
you have consumed all your time plus a little more.
Please ask just one more question.
Oh, sure, absolutely.
That last part threw me off. You're saying that they would have never, ever needed this type of medical treatment
Yes, yes,
if somebody had caught that?
correct, because
It's not that it would have been delayed
Right.
or anything at all. It's that this thing would have never happened.
Dr. Lorenzo testified that if he had bothered to turn the page from the prior page he did look at, that he would have seen this, he would have known that
I
it was
understand
multiple
all that.
myeloma. You do not treat multiple myeloma surgically. You treat it with radiation. There was testimony at trial about that.
All right.
So this
Okay.
surgery would
You
never
don't
have
need to go
occurred.
further. That answers my, thank you, Chief Justice.
Mr. Parrish, even though your time is all gone, I will afford you 3 minutes for rebuttal.
Thank you so much.
Since we helped you consume it.
May it please the court, Dinah Stein on behalf of Arturo Lorenzo and UNESCO. And we agree with Mr. Parrish that this is a simple case. It's a simple case of lack of proximate causation. And I would like to address Justice Lewis's concerns about the practical effects, and really if this was a correct decision in the trial court and by the third district majority. And it absolutely was, and there's no reason for this court to do a second-tier fact analysis in this case. The majority was absolutely correct. The first thing I want to address, in case it's even an issue, is Justice Labarga's question about what the death certificate said, just to make it clear that this was a clear case of exsanguination and nothing else. The death certificate said heart failure, which everybody agreed at trial. Our side, this side, everybody, all the experts agreed was secondary to blood loss. And what happened was, as soon as the surgeon started incising during the operation, she started losing massive quantities of blood through what was thought to be bone. And tragically, they just kept operating. Nobody stopped them as blood pooled, as blood came out of her. And that's what caused her heart.
Here's my question, though, and goes back to the causation issue. Surgery, the anesthesiologist is the key person who has to clear somebody for surgery.
That's correct.
So if somebody's going for a minor surgery that's elective, and there are contraindications, whether it's the EKG, the blood work, which is all has to be reviewed by the anesthesiologist before that. To say, well, oh, it was okay, she went to surgery. If it's an unnecessary surgery, he contributed to her going to surgery by not stopping isn't that the argument?
That's part of it, and yes, let me address that, and I'll split it up into the two alleged acts of negligence, because one was the EKG and one was the urine. The EKG, everybody agreed, if he had ordered a repeat EKG, it would have been done in 20 minutes and come back normal. Plaintiffs, 2 experts agreed to that it had nothing to do with the case. So we're talking zone of risk. There was no zone of risk from the EKG. It had 0 to do with her even going into surgery and, of course, what happened in surgery. She did not die of some kind of cardiac pre-existing condition. So that should be off the table.
How
That
did
wouldn't-
she, what was the testimony about how she died? Was the tumor too big and she just bled to death because of the tumor?
The testimony was that, and it was the plaintiff's experts testified that the surgeons, there was a lot to be said about their age and the techniques they used, that they used the wrong technique. They used a technique that was archaic and allowed too much time to bleed, and it wasn't enough time to stop the blood and turn her over and put, some kind of wax on the bleed. So that was the testimony. It was just her, she kept bleeding, so it had nothing to do with size of tumor, at least in the testimony. It was just these people let her bleed to death during the surgery. But of course, if the EKG had been redone, the surgery would have happened 20 minutes later.
You were going to talk about the protein.
Absolutely. And first of all, let me back up to the protein issue because it's undisputed in this record, including with plaintiff's witnesses, that the Dr. Lorenzo didn't clear. Well, he didn't clear her for surgery. I mean, they agreed he never got to the second page with the protein level because Dr. Velasquez, who was the assigned anesthesiologist who was in the operating room, showed up and said, I'm taking over from here, and started from stop to finish. So even Dr. Mazzai, which is plaintiff's anesthesiologist expert, agreed he never looked at the second page. And so Dr. Mazzai tried to take it a step further and said, but he should have looked at the second page because he put his initials on a page, and therefore in his mind, he believed that he was the anesthesiologist in charge. That's our whole second argument, is that Dr. Mazzai came up with testimony based on facts that just...
Let me ask you this. Did the jury hear the evidence that Dr. Velasquez cleared her for surgery despite the EKG and the protein in the urine?
Yes, Your Honor, from Dr. Velasquez,
Right.
from Dr. Lorenzo, and the medical records showed it.
Well, let's go, but Dr. Velasquez was a Fabre defendant.
Yes.
Wasn't brought in by the plaintiffs. And the theory against Dr. Velasquez, as it went to trial after the directed verdict, was that he was negligent during the surgery. Dr. Lorenzo was sued for negligently clearing him. So it's a big difference when someone's a Fabre defendant and not directly being sued by the plaintiff. Would you?
I don't take issue with that for the purposes of this analysis, but I'd like to get back to what the evidence was, because the evidence was that Dr. Lorenzo didn't clear her for surgery. He never saw the second page. There's that. He just, and to
But
go
that's a
with
pretty big deal. I mean, it's a pretty big deal. How old was this plaintiff?
45.
Okay. To be going in thinking you're having this simple surgery to check out what's wrong with the tumor, but in fact what you have is multiple myeloma, which is, if somebody had looked at the second page, would have stopped the surgery. And maybe that's not proximate cause legally, but to me, it's much more direct than when we were talking about, the trial judge talked about the cab driver taking her over, that if she couldn't get a ride over, there wouldn't have been the surgery.
Because, well, I'll take it a second step. First of all, and I want the court to understand the evidence, because again, Dr. Lorenzo wasn't the one who cleared her for surgery, and that's the reason he didn't see the second page of the labs, is because he wasn't assigned to the case. But
Well, that would
I'll keep
mean
going.
that there was no duty of care.
Right.
So, but that's not what we're here on. We're here on proximate cause. The assumption is that there was a breach of the standard that there was a breach of the standard of care, but there wasn't causation. I thought that's what we're here on.
Right, and no expert testified at trial that had, plaintiffs try to make the inference, but nobody testified that had Dr. Lorenzo seen the protein, called the primary care physician, called Dr. Yates, that the surgery would be permanently canceled. Dr. Mazzai didn't say that. He just said it wouldn't have gone forward that day. And Dr.
No, I thought Dr. Yates said that if he knew about the protein, he would have canceled the surgery. I mean, that's,
Well, the problem with that is it's undisputed
did
that...
say that, right?
I believe he did. He knew about the protein. The protein was seen. That's the other
do you
problem with it.
disagree that she actually had multiple myeloma, that that's what her...
No,
So that's not, was that in, so they didn't even
That's-
concede that in the
that's
trial?
not disputed.
It is disputed?
It's not disputed.
So she did have it?
She had it.
Okay, so a person with multiple myeloma going in to have her skull cut open, you don't see that the surgery would never have occurred if people had paid attention to something simple that on the second page. I mean, how her primary care doctor, I assume, was sued also?
I believe he was originally sued. I think everyone was
So
sued.
would he have been able, would that have been, if he had been sued and in the case, would that have been appropriate? Or are you saying, because everything that happened during surgery is the only proximate cause of why she died?
Everything that happened, well, no, because the plaintiff sued for taking her to surgery and for the surgery. So that was their
So there's two
theory of the
parts.
case.
So anybody
Right.
that contributed to her going to surgery was part of the proximate cause of her death.
Incorrect if the person didn't contribute to her going to surgery. We have to look at each person individually. And nobody said that Dr. Lorenzo had a duty. Nobody said that he had a duty either to diagnose multiple myeloma. In fact, their anesthesiologist agreed he wouldn't put that on the standard of care, or to stop Dr. Velasquez when he showed up and said, "I'm sorry, I've started this evaluation. Now I need to finish before you take over." And that was the problem with it, is that he was a person who never cleared her for surgery, and nobody testified at trial. And in fact, the plaintiff's expert agreed that he didn't
So
see...
what Judge Emes says in his dissent about the testimony is absolutely incorrect based on the record?
A lot of it, I believe, frankly, was. I mean, there were suggestions that she died in the descent of cardiac arrest. That's not in the record at all. So there are some, and of course, the dissent doesn't talk about, or dissent's not a basis for jurisdiction.
Oh, no,
but I want-
going back to, I thought you went beyond that and we're talking about whether Dr.
No,
Lorenzo
but that's-
was even negligent.
When Justice Kennedy talks about the statement by the third district that nobody testified that he fell below the standard of care such that it caused her death, I mean, that is part of it, is that this person undisputedly wasn't assigned to this case. He undisputedly didn't finish the evaluation because the assigned person showed up. He was helping out, and without dispute, he just didn't get far enough to even see a urinalysis result. So we shouldn't even it's beyond proximate cause. We shouldn't even be at looking at him as a cause of her going into surgery as to that. Maybe with the EKG, but of course that's a whole different proximate cause analysis because he saw it. But as to the protein, he simply didn't see it. So how do we now pull this person into this duty that nobody said he had a duty to diagnose multiple myeloma? And we have just one expert who said, just because he signed this one page, which he admitted, he said, as long as I talk to the patient and look at her chart, I have to put my signature there. But this one expert said because he put his initials on this first page, that meant in his mind he cleared her for surgery. And that's the third district, and that was before the third district, and that's what they found, is that that's not enough to now put on this person who helped out but just never breached a duty of care as to the protein. That's why there's no duty or cause as to the protein. So again, we just never get to him clearing her on that issue. We've got the EKG, absolutely no causation, and the multiple myeloma, the urine protein. But just to quote the experts, Dr. Mazai never said that this surgery would be permanently canceled had he alerted anyone to the urine protein. And again, the record's undisputed that Dr. Yates had it come back to him with the approval of Dr. Venero, the primary care physician, and approved her with that urine. So they're the ones who saw it, not Dr. Lorenzo. So again, there's simply nothing.
I'm confused. So Did Dr. Velasquez show the surgeon the protein results, your analysis results?
He did not.
How did they see it?
Because when Dr. Yates had asked for a pre-surgical clearance beforehand, which is when Dr. Venero ordered the labs went to Dr. Venero prior to the surgery. He actually signed off on the labs which had the abnormal protein, the same exact labs that...
So the surgeons who did the surgery signed off on the same labs?
There was testimony that was not in dispute that after Venero...
Because I thought I clearly recall Yates' testimony that if he had known, he would have canceled the surgery.
There was a lot of inconsistent testimony by Yates, but Yates got the lab report to him clearing her. Whether he looked at it or not is a different story. But she was approved for surgery with those labs by the PCP as ordered by Dr. Yates. So again, we have an undisputed fact that she had already been approved for surgery based on even with the urine result. The other thing I want to point out is the testimony was undisputed that urine protein is not a surgical risk. Everybody agreed it doesn't make you any more risky for surgery. They're trying to put a duty on anesthesiologists to diagnose every disease. Again, I don't think we have to get that far. Their duty, as stated in the testimony, is to look for surgical risks, not to
Well, I mean, I
diagnose.
think that's what's happened in this case is the way in which it appears the third district wrote this opinion. Because the concluding line says that the primary cause, it doesn't say that the sole and exclusive cause was the actual, what caused the death. That's what I think has set off this chain of events. I mean, it seems to me, you would have to agree, I think, as an officer of the court, that in any negligence case, it doesn't have to be just the primary cause. You can have contributing causes.
Oh, I
Agree?
can't disagree with that,
You
Justice
disagree?
Lewis.
You can't
No, I
have
said I
contributing-
don't disagree with that.
I'm
I
sorry?
agree.
Okay,
I agree.
well, that's what I'm saying, and that's what set this chain off. What you have described this morning is a case where there's no evidence, not that it was the primary cause, but that there's no evidence as to the other people. So that's where I'm a little thrown back a little bit, because the opinion on its face is very, very slim in its factual discussion. But that concluding language, I think, creates a harm to all Florida law. That it's the reason they're deciding it is because what the primary cause was.
If the language wasn't perfect, I would submit that the facts of this case don't arise to some kind of an injustice. It's
Well, no,
not
I
a
mean,
case.
just the language, it does do harm, in my view, to other cases that well, if you don't have primary cause, you can't take the case, even as a defendant suing for contribution or what have you. So it seems to me, the more I think about this, is that yes, we do have jurisdiction, but the result may not be any different.
The result absolutely is not different.
Yeah.
Obviously, we maintain no jurisdiction because
understand.
any litigant can read the language that says we find no testimony that there's a breach of the duty such that it caused, and know that that's what it meant without getting to the second part, which is a little loose, but it doesn't change the law.
That's
well,
very
no.
definitive. It's not the primary cause, so there's no action. That's pretty firm.
The third district clearly wasn't intending to make broad
Well, I
sweeping
know, but
law.
that's why we have to be careful when we write opinions.
Well, and
because that's
that's-
what it leads to.
And the concern being, it's never been clear, at least to us, what the jurisdiction was. I mean, there were no less than 8 decisions cited in the jurisdictional brief of just about every different concept, and what we're trying to bring this back to is just this really is a very simple case. It is a simple case of causation. It's a simple case of no duty, no evidence of breach of duty, and this isn't the case to reverse or stop an injustice because this
Well, I mean,
defendant should not have been
The point being
sued.
is that we ought not have law out there floating around that people can hang their hat on and say, well, you see, it must be only the primary cause. You can't have an action for a concurring cause.
Clearly, this court's jurisprudence is long and long-standing, and we have
Exactly.
McCain,
That's why it's
and
in
the third
conflict with
district
that
wasn't.
statement.
The third district wasn't intending to do anything
Well,
to
look,
disrupt
I
that.
understand
And I
that you-
submit that the opinion doesn't do that. The opinion doesn't do that. It just.
Oh, well, that's
has-
where we disagree. But I do, I mean, I can see all kinds of problems in trying to make an anesthesiologist responsible for diagnosing, based on the lab report, every condition that a patient may have. So, I mean, I fully appreciate that, but that doesn't go to, see, this case is bouncing back and forth on, is there a duty to do that? Is there a cause? And the causation is what creates a problem that I see. But please go ahead, I don't want to take more of your time.
Well, again, we would submit there's no jurisdiction, but at the very least, if the court needed to clarify that primary cause isn't part of this court's jurisprudence, I appreciate that, but it certainly wouldn't change the result here. Thank you, Your Honors. If Your Honors don't have additional questions about the evidence, then I will sit. I appreciate your time. Thank you.
I just have to clarify what I think are two mistaken representations of the record. First, there's absolutely evidence in this case that Dr. Lorenzo cleared her for surgery. He answered an interrogatory that said he didn't. Keep in mind, this was a directed verdict. All evidence and all inferences that we presented are deemed admitted by the defendant. So the interrogatory response that he did it, not that I did part of it, but that I did it. He put the signature on page 1654 is the form. His signature is in the block that says physician signature. Dr. Velasquez then has to sign outside that box. Also, he got at least all the way through the renal section, and it's the renal section that is the real issue here, because he just didn't look. It's not because he didn't have time. He said he was there for 3 to 5 minutes. He looked at the first page of labs. All he has to do is turn the page over. So there was definitely testimony, and that's not why the trial court granted summary judgment, or why the third DC affirmed it.
Did Dr. Velasquez dispute Dr. Lorenzo's testimony that he walked in while Dr. Lorenzo was in the process and took over?
You know, the funny thing is that he wasn't asked a lot about that handoff. In fact, he had very little recollection of that day. From, like, I think it's R11 through 1113. He's asked a series of questions, and he doesn't have a lot of memory. He says, well, my usual practice would be that I would do it from the beginning to the end. Keep in mind, he's negligent because he looks at it and doesn't think it's an issue and doesn't bring it to anyone's attention. But again, under Saunders, you look at each separate physician.
Right, I'm just trying to...
Sure.
Factually, it is undisputed in the record factually that Dr. Lorenzo started because Dr. Velasquez was late, but then Dr. Velasquez finished and was the one that told the surgeons they could go ahead, and he was the one that was in the...
So our expert testified, among other things, and again, another, I think, mistaken mischaracterization of the record that occurred this morning. Dr. Mazzai did testify that if you sign it, you own it. He did testify, and this was unchallenged. There was no Daubert or Fry motion directed at Dr. Mazzai. He testified without any challenge, and he's got the credentials, and he testified at pages 1261 through 1263 of the record. So he's saying, if they don't have kidney disease, you don't have an explanation. You want to know, why is this urine abnormal? Is it going to affect the anesthetic? But equally important, is this a sign of what's really going on with the patient? Since in this case, the diagnosis was not known, that's why they were trying to take samples of it during surgery. That's R1261. He then goes on to say at 1263, for an elective case, which this was, particularly an elective case where we just don't know what the tumor is, so we don't have a defined diagnosis, you have to say, is this the piece of the puzzle that's missing? Let's evaluate this before we proceed, because if the diagnosis is multiple myeloma, you don't do the surgery. And we know
You need
it was multiple myeloma.
your time is up. You need to sum up.
So yes, there is record evidence that Dr. Lorenzo did clear her for surgery, a 45-year-old mother of 2, for unnecessary surgery during which she died, which is not a bizarre or freakish or improbable event during surgery. Look at Davidson versus Gaylord to that effect from the 1st District. So we would ask the court to reverse and remand.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.